In the summer of 2024, Louisiana made headlines across the country. The state passed a bold and controversial law, House Bill 71. It required every public school classroom from kindergarten to college to display the Ten Commandments in large font, framed and predominantly placed so it would be the central focus of the room. Lawmakers said it was about educating students on America's moral foundation, but critics quickly called it what they believed it really was, an unconstitutional attempt to push religion back into public schools. The new law didn't sit well with parents, teachers, and civil liberties groups. Almost immediately, a lawsuit was filed, and that's how Roake and Brumley began. The plaintiffs, a group of students, parents, and educators backed by organizations like the American Civil Liberties Union, Americans United for Separation of Church and State, and the Freedom from Religion Foundation. They argued that forcing religious scripture into classrooms violated the First Amendment's Establishment Clause, which bars the government from endorsing any religion. And they had precedent on their side. Back in 1980, the Supreme Court had already ruled in Stone v. Graham that a nearly identical Kentucky law also requiring the Ten Commandments in classrooms was unconstitutional. Fast forward to 2024. The federal district court in Baton Rouge saw the Louisiana case the same way. In November, it blocked the law before it could go into effect. But Louisiana didn't back down. State officials appealed, taking the fight to the 5th District Court of Appeals, one of the most conservative appellate courts in the country. And in June of 2025, the court issued a unanimous decision. The law was unconstitutional. The state could not hide religious motives behind historical claims. Yes, the Ten Commandments are old, but that doesn't make them secular. The court pointed out that HB 71 forced all students, regardless of faith, to sit beneath a government-approved version of a specific religious code every single day. It was coercive, and it clearly violated the Constitution. The court also looked at the intent behind the law, and frankly, lawmakers didn't help themselves. Many had openly admitted that the law was about restoring God to the classroom. Some had even said it was a way to fight moral decay. That sealed it. So what was the impact? Roake versus Brumley reaffirmed a crucial constitutional principle. Public schools aren't churches, and no matter how well-intentioned a law might seem, if it favors one religion, it excludes everyone else, and that's something the First Amendment simply doesn't allow. Please share your thoughts about this appeal in the comments below, and if you like this video, please hit subscribe for more arguments and appeal summaries every week. Until next time.